Welcome to For Better or for Court, Family Law in New Jersey.
Welcome back to For Better or for Court, Family Law in New Jersey with Ms. Alix Claps. Alix is a partner at Heyman & Fletcher and a certified matrimonial law attorney helping New Jersey families navigate divorce, custody, and complex family matters with clarity and care. I'm Evan Mack, and today we're talking about a question many parents wonder about. How much say do children have in custody decisions? Alix will explain how New Jersey courts weigh children's preferences, what age and circumstances matter, and how parents can approach these conversations in a healthy, legally mindful way. If you're navigating custody or co-parenting, understanding how your child's voice is considered can help you make informed decisions and reduce conflict. Miss Alix, my dear, welcome back.
Hi, Evan. How are you?
I'm swell. Alix, at what age does a child's preferences start to carry weight in New Jersey custody cases?
It's a spectrum. I mean, there are degrees, and it also depends a little bit on the maturity of the child. In some cases, you're going to have a 9-year-old whose perspective is really appropriate to be heard by the court. 9 is about the age where you see commonly an in-camera interview with a judge too, so they're really hearing directly from the child. A younger child is more likely to have their thoughts heard through an expert or a guardian ad litem, not directly to the judge. As the child gets older, I think 12 is a pretty solid age where a child's opinion is going to be given weight. More weight than even, their input at 9 is helpful, and their input at 9 can sometimes be surprising. Some of the results of in-camera interviews with the judge are really enlightening from 9-year-olds, because ultimately, mostly they want their parents to get back together, and that's almost never an option when if we're at a point where a 9-year-old's having an in-camera interview with a judge, that ship has basically sailed. A 12-year-old's got a slightly different perspective. They're a little more self-focused on. They understand their needs better. They know what their routine is. They know what their preferences are. So that's when their opinion gets a lot of weight in a court directed schedule. And then once they're about 16 or 17, the court, you're not going to be able to force a 16-year-old into a car for a parenting time exchange. No. And most judges understand that. They look at different things. If they're hearing from a 16 or a 17-year-old, odds are they're hearing about, was there acts of parental alienation? Did somebody withhold a child? How did some kind of dispute come about between a child of that age and a parent? Or we're figuring out something weird happened. Like there was a move and we're trying to figure out intrastate something, or we're getting prepared for the child's going to go to college, and we're looking at those sorts of things. So you're looking at something different with a child of that age than you're looking at with a 12-year-old or a 9-year-old.
So how do these judges evaluate whether a child's stated preference is genuine or maybe influenced by their parent?
It's almost never an opinion that they get from a child in isolation. They're going to ask certain questions of a child in an in-camera interview. Kids are surprisingly open with judges. The judges, we think as adults, judges are scary people in black robes who make decisions and have a lot of authority. But kids really do tend to open up to family court judges they have a lot of experience doing this. So they'll know if a child is reciting something that was told to them, if they're being unduly influenced. There's also going to be external signs of it, because if there's a forensic evaluator, if there's a best interest evaluator in the picture, they're going to watch the kid interact with each of the parents. That's extremely informative, and that's going to also help the judge understand, all right, who's influencing the child in a more general positive way, and who's trying to use the child as a tool to get what they want from the court.
So how do Jersey courts balance a child's preference against other factors like, the parental fitness or maybe the stability?
The child's preference is only one of the statutory listed factors, and even that is caveated by when of sufficient age and maturity. So a child's never going to be the sole decision maker. The child's never going to be given that kind of authority. That power dynamic in a family is a very dangerous thing. The child shouldn't have that. And good judges let the child know at an in-camera interview or when their opinion is being elicited that I just want to hear what you have to say. I'm going to make decisions based on a lot of different information, but this is going to affect you. So it's only fair that you get to tell me anything that you feel like I should know before I make my decision. And that's I think a healthy dynamic for a child. Doesn't give them too much pressure and it doesn't give them too much power.
Can a child's preference ever override the standard best interest of the child analysis?
I don't think it does. I think in certain cases they align. I think you'll see sometimes where a child's preference is reflected very clearly in a court's decision, but it never conflicts with all of the other information. More often, a child will take a very clear stance on, I don't want to see this other parent, or I don't want to do this thing. And the court's going to say, you know what, that's sorry, that's not up to you. We're going to try this, and this. We're going to try therapy, family therapy, or something like that. We're not just going to let you say, no, I don't want to see my other parent anymore.
So, Ms. Alex, what role do mental health professionals or guardians ad litem play in assessing a child's preference?
So, a mental health professional who's doing a best interest evaluation, they're going to be putting together their opinion, an objective opinion on what they think, taking into account all the statutory factors, taking into account they're going to do mental health testing of the parents. They're going to see the dynamic of the child interacting with the parents. They're going to put together a comprehensive evaluation of what they think the court should do. Guardian ad litem is going to do a similar thing, but the guardian ad litem does less sort of independent investigation in terms of they don't run the mental health tests on the parents because they're frequently not qualified to do that. Guardians ad litem are often lawyers. They don't absolutely have to be, but they're almost always lawyers. And they're going to take the child's opinion into account, but they are also not the lawyer for the child. They are a lawyer who is supposed to present to the court what they believe is in the child's best interest. That can be a difficult needle to thread. And guardians ad litem are used for adults who are incapacitated too. It's not just for children, but we see it most often for children in the family law context. Their opinions carry a lot of weight because they are also making a more objective determination than either of the advocates for the parents. You know, if I'm an attorney for mom, I'm presenting a case that I believe in. I'm not going to present to something to the court that I do not believe is a valid approach, but it's going to be mom's argument largely. It's going to be from mom's perspective. The guardian ad litem and the best interest evaluator have professional obligations that go beyond what the child wants or what either the parents want. They are answerable to the court.
You kind of talked about different ages in this episode, but how might that child's age or maturity or maybe their experience in life, affect how much their voice is considered?
Age is one factor. Certainly, the older the child gets, the more autonomy they have. That's true within a court context and outside of a court context. But you also have to look at a lot of family court involves children with special needs. So a child who's on the spectrum, a child who's got a learning disability, a child who has ADHD. For example, children with ADHD have a tendency to have difficulty with transitions. So the court, the parents, the advocates need to be looking at, all right, is a 223 going to best serve this child? Or even if it's not the parent's preference, is a slightly longer time with each parent so the child isn't having to do as many transitions in the best interest of this child? So you're looking not just at the age, but you're looking at all of these the children's needs and abilities. Similarly, if you get a child who's an elite gymnast, whose best interest for that, and if presuming the parents at some point decide to put this child in gymnastics, this is not a thing that happens out of the blue that a child gets to this level without both parents being involved. Are we pulling this child out of school? Is this child getting privately tutored? Is one parent basically leaving their job to travel with this child? That's certainly going to have an impact on parenting time. That's going to have an impact on decision-making authority because day-to-day decisions have to be made by the parent who's physically there with the child. So all of those circumstances, along with age, go into what a court's decision is going to be.
So how should a parent respond if their child expresses a desire to live primarily with just one of them?
Depends on if they tell me they want to live primarily with me, I have to look at it differently than if they say I want to live primarily with daddy. Because are they just telling me what I want to hear? Are they telling me they don't want to live with me because I won't let them get McDonald's for dinner that particular night? Are they, I've got a 4-year-old and I go alternately from being the worst mommy in the world to the best mommy in the world in about 30 seconds flat. So do they really mean that they want to live primarily with daddy because daddy's closer to their school? In
Hmm.
daddy's building, their best friend lives down the hall. What is it about it? I mean, or is it that, there are no rules at daddy's and they have no bedtimes, and I'm slamming daddy only because at mommy's, maybe there's no bedtime. So the child want to be there because the child gets to do what they want. The question, you don't just listen to what the child says, you have to figure out what the child means. What's the child
Hmm.
actually telling you?
Can children change their preferences over time, and how does the court handle that if that's the case?
Absolutely. Children change their preferences frequently over time, because their needs change and their preferences change, and there is a gender component. A teenage girl may want to spend more time with mom because mom has a little more experience being a teenage girl.
Mhm.
Or alternatively, you get the moms and teenage daughters just butt heads all the time. So maybe it's better for that relationship long term that the teenage daughter spends more time at dad's. There are all sorts of dynamics at play that each family is, all happy families are happy in the same way, and all unhappy families are unhappy in different ways. Is that the opening line of Anna Karenina? I'm screwing that up, but it's the idea.
I know what you meant, though.
Every family has their own dynamic, and a child's needs and a child's preferences will change with their needs, even if they can't figure out what their own needs are.
So, Miss Alice, what practical steps can parents take to ensure their child's voice is heard without putting too much pressure on them?
Listen to the child, but don't immediately react to the child. See if are they just having a bad day? It's the same thing. Like, do they want to quit soccer because they really want to quit soccer, or is it a little cold out today and they don't like the idea of playing outside today? If they say
Hmm.
it repeatedly over time, maybe they mean it. Maybe they're really done with soccer. And I'm using that as an example, but it's an analogy to, do they not like doing a transition on Sunday evening? Would they rather have the transition happen at school drop off on Monday, even if that means then the parents have to figure out how to get the weekend stuff back and forth without the kid being involved? Because you don't want to be dragging a duffel bag to school. Those sorts of things. A lot of these are those small issues, and they spiral when things get either underreacted to or overreacted to. Everything needs a beat. You need to take it in, absorb it, figure out what it means, and communicate with your co-parent. Is your co-parent getting the same story, or is the child going to the co-parent and saying, I want to audition for travel soccer? Are they getting two different stories?
Awesome. Miss Alex, thank you so much.
Thank you, Evan.
That's a wrap on today's episode on For Better or For Court. Huge thanks to Alix Claps for explaining how New Jersey courts consider children's voices in custody decisions. For more guidance on family law and resources for parents, visit HeymanFletcher.com. Don't forget to subscribe and join us next time for more insights on navigating divorce, custody, and co-parenting with clarity and care. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.